How does custody affect property settlement? This is a topic rarely discussed, and the hidden connection is rarely explored, but people quickly discover it if their ex is using it to their advantage. So today we're going to be talking about how custody can affect your property settlement and what the law says in Australian Family Court about it. What do you do if your kids become bargaining chips, and some strategies that you might be able to use? Welcome, Mark.
Hello, Laura. Hello, everyone.
Today's topic is a bit yucky, and I think we've kind of danced around this for a very long time because we've been a bit nervous to touch on it, but it does seem to be an issue that comes up frequently for people, particularly our members in the Q&As. Let's just dive into it and see how far we can get through it. But just before we get started, we will be discussing topics of coercive control and family violence. If you get triggered by that, please call 1-800-RESPECT or 13 11 14 Lifeline. And a reminder that Mum is not your lawyer and I am not a lawyer. And this is just an educational discussion about family law in Australia and other countries where this behaviour goes on. Let's get to the jingle and let's get started.
Hello, I'm Laura, divorced mother of 3, and I'm here with my mother, Lynette Galvin, with 35 years' experience in family law. You're listening to the Divorce Course podcast. Through our candid discussions, we hope to help you through your divorce or de facto separation. We will be answering the most commonly asked questions and covering the stages and steps that you will face on your way to freedom.
Now, Mum, in my head, custody and parenting orders are completely separate from property and the money side of things. Is that true in family law?
No, not really. Not really. You do have people who are just trying to sort out property matters and people who are just sorting out kids and their property's all sorted or their kids are all sorted. But property involves an exploration of contributions and of your future needs. And one of the aspects that the court looks at for property settlement is the arrangements for the children.
Right. So technically then, yes, it does count towards property.
It used to be in one place. It used to be in Section 75(2), and it would talk about whether or not a person has they used to say care and control of a child under the age of 18, and that was a factor that the court would use to perhaps raise their percentage. Now it's in 2 places. It's now called whether a person has the care of a child under the age of 18. They took out control, which is nice. And the other aspect is in the need to provide housing for the children. The court is to take that into account when working out property settlement.
Right. So technically then, if you have more share of the child or the children, technically your future needs are greater.
Yep.
So technically you should get a larger percentage of the property pool.
Yep.
Right.
Yep.
Does that happen though?
I think so. I think it's certainly one of the things that goes into the dynamic. So the court no longer has to consider things in a certain sequence. They're looking at a range of aspects of people's lives, and the children, the care of the children and the need to house the children are just 2 of those factors that they will take into account with all of the other issues like age, state of health of the parents, and all those things going forward, financial resources and so forth.
Right. So a lot of people listening, they've got their kids, you set up their lives, they've got the little chore charts, they've got their homework, they've got the place to put their school bags.
Oh, that makes me reminisce.
And they're living their lives and the kids are doing their thing and they've got 12 years of schooling to get through. And then one day the listener here has either been told we're breaking up or has told their ex they're breaking up. But the amount of emails we get and messages we get from people saying, I want to keep the kids in their little happy bubble, in their little nest, and I really want to just stay that way. How can I make sure my divorce works out that it just stays that way and that person who wants to leave just leaves? What kind of things can you say to those people, and can that happen?
It's very hard. It's very hard. There is a thing called nesting, and I think that's come up a couple of times in our Q&As, where the children stay in the house and the parents move in and out on a weekly basis. It may be that they don't talk to me if they don't need a lawyer, if it's working, but in my experience, that rarely works for more than a couple of months. I understand the need for the children to be in a happy bubble or to try to keep them in a happy bubble, but there are going to be changes. And even if you do everything possible to keep them in the place and you and your ex don't fight in front of them, they're not silly. Kids know. They pick up on the atmosphere. And I think sometimes they're more stressed if they don't know what's going on. It depends on the child. But you can be sure that there are a lot of kids at school in the same sort of situation. And that's who kids talk to. When their parents are separating, they talk to other kids about the arrangements.
So you talk about that court saying that there needs to be housing and stability for the children. So why can't they just say to the court, well, I just want to keep the house because I want the kids to stay in the house? Wouldn't that be part of the property negotiation?
Absolutely. Absolutely. So that component of keeping a roof over the children's head is brand new, only a few months old. There aren't many cases that are turning on that point for me to talk about. But now certainly that will be the case. And I suspect the way it'll go is that if it's just a minor tweak in the property pool, and that's the difference between keeping a house and not keeping the house, the court may be inclined to give a little bit on the upper range to allow someone to keep the house. If it's within the court's power, if it's within the proper range of property settlement for a person, but they might need more cash and less super so that they can refinance the house, I certainly imagine the court will do that going forward. So you do need to make that submission to the court, set out clearly how the children are welded in their community there, set out clearly how you can afford the property. I think that would be the way to do it, and really show the court a way that they could allow you to retain the home and the kids retain their stable environment.
We did an episode 2 weeks ago, I think it was called, about primary carer.
Yes.
And what it means and why it's important now. So obviously, if you're the primary carer moving forwards with your children's orders, that you're going to be looking after the children the majority of the time. Like we've said, it can have an effect on your property orders because you've got that need and more needs financially to look after the kids moving forward.
And that's not just keeping a roof over their head.
Yeah.
It's all the other expenses.
Oh, gosh, yes. Kids are expensive. They're like money pits. Okay, being a primary carer potentially means you're going to get a bigger share of the property pool. Okay, and you're saying that this has been for a while, but the new consideration that's just recently been added is the consideration for the kids' housing. I can see a big problem here. I can see people being strategic, and we've heard of people being strategic, where they want to sort out property first and not touch children's because they know that is the rule, that there may be more given to them in property. That's one of the things that we see. The other thing is that we see is that the ex says, unless you agree to this property thing, I'm going to go 50-50 for the kids, or I'm going to go 80-20 for the kids. Or they basically just use the kids as a bargaining chip. Do you see that happen a lot, or is that something that's just starting, or has it been going on for ages? Is this an age-old hidden connection battle?
It's been a thing since 2006 when the law changed. At that time, it's changed back again now, or differently now, but it used to be that the court had to consider substantial care, and sometimes it was 50-50 that they were to consider. And so many people using that argument from the court, using that law, would then put forward a very strong argument for 50-50. And the consequence of that was a more levelling of the property pool between the persons, so that the primary carer, who used to be the primary carer, doesn't get that uplift as a result of the kids' expenses going forward. Because whatever people think, child support just doesn't cover things. It just doesn't. And so, yes, we saw that really strongly from 2006 on. I don't recall it before then. And now that the court's trying to kind of put the toothpaste back in the tube and say, now we're only looking at best interests of the children. Don't come with that 50-50. We don't have to think about that anymore. Unfortunately, it's been said, and people are now, even now, and it's a year later, are still insisting on 50-50. And I see it a lot. And I also see it where a person wants the kids to be put in harm's way if there's been an abusive ex. And so that's your vulnerable point, and they know they can trade off. And a lot of people do trade off property for the security of the kids.
So that is a thing that's happening. And that just horrifies me to think that people out there are just like, oh, how can I get more money? Or how can I leverage this? So obviously those people probably don't deserve to have their kids anyway, to be fair. So you're seeing a lot of people where they've basically just got to go, fine, I'll take that, whatever, as long as the kids are safe. But surely there's got to be some better ways, Mum. Like how can people protect themselves from that bargaining? I'll give you an example. Imagine someone texted their partner and they said, I'm going to make sure you end up with no property and I'm going to get the kids 50-50. Or you better let me get everything I want or I'm going to go for 50-50 of the kids. They text that to their ex. What can that person do?
Attach that to an affidavit to the court and say, this person does not have the children's best interests at heart. They're trading on the kids. They're just trying to use the kids. I mean, the other thing you can do, Laura, is educate yourselves, and our listeners are, that the court no longer does 50-50 as of right. And whilst it may occasionally be an outcome, it's not going to be as often as it has been in the last 17, 18 years. And so if you ask the court, then I believe the court will properly apply the law. They do properly apply the law, or they get appealed, and they will look at who was the primary carer for the children, who's therefore going to have the children going forward, because best interests of the child are paramount. And someone who would send text messages, like you just said, is not really worthy, are they, to be the parent, the sole parent of the child, or even to have too much time with the child, I'd suggest.
And look, I do get sent constantly a podcast that is quite horrible. To be fair, I'm not going to name them, but the argument there is, now that they've changed the laws, every single father is not going to see their child. And I do want to point out that it's not gender related. And also, when it comes to the statistics of the family court and how Mum talks about how the court determines the child's best interest, most people don't end up in court. Most people could. If they're working well and their co-parenting situations are perfect, then 50-50 may be okay for the kids or whatever works for the families. There's a lot of divorces and a lot of de facto breakups in Australia, but only a very small percentage end up in the courts. And so if you are listening to this and you're feeling disheartened because maybe you're not the primary carer and you're worried, but if you're not going to end up in court, then it's not going to be decided by a judge. If you're reasonable, if you're amicable, you're a good person, you're of course going to do what's best for the kids. And you're not going to get your kids taken off you. The kind of situations and the cases that come out of the court are really quite extreme, horrible ones, to be fair, the ones that we see. So, Mum, if an ex threatens to withhold the kids unless you agree to property, the best defence you've got is to show where they've stepped or give proof to the court. What would the court do in that instance? They'd just be like, you're an idiot. So...
Yes, I can distinctly recall several judges in my career saying you're an idiot.
Okay.
I can imagine the appeal bench, 3 serious judges going, sir, you're an idiot, ma'am, you're an idiot.
Yeah.
No, they're not going to do that. But this is evidence of a person's attitude. If they are not silly enough to send a text or put something on Facebook or Insta, whatever, if they say it to you, then you need to record that. I don't mean record, but type it into your whatever notes you're making. Yep. And maybe write a letter to them or to their lawyer. And you know what a fan I am of quoting words back with a lot of white space. So you would write back and say, today your client said this, inverted commas, bold letters and capitals. If you don't get it, I'm going to take the kids, and just send that to their solicitors. In other words, dob them in. And if they either deny it, which is fine, but they won't do it again, or they may admit it, or they may say nothing. And if they say nothing, you can put that into evidence. If they admit it, you can put that into evidence. And if they deny it, then that can be challenged also in the witness box. But at least you're speaking your truth, because the best interests of the children was looked at by the court from 1976 right up till 2006. So we've got 40 years almost of case law. And those sort of attitudes tell the court that you are not child-focused.
Right, and I think that's the term there that you need to, because even if they don't put it in writing, I guess you could see it in maybe in their behaviors for negotiating. If they go to do it and then they change their mind at the last minute, or if there's a lot of dilly-dallying or delays, maybe you could put that in a chronology and show the court every single time it got close, they just completely changed their idea.
And people have arrangements in place way before they ever get to trial, right? And in that period of time, the other person may be having lots of time with the child and it might be working well, and you can tell the court that. If it's not working well, you've got evidence then of what's been happening in the meantime that needs to change. And one of the things that sometimes can demonstrate that it's not going well is the number of times the person who's insisted on 50-50 has bailed on picking the kids up from school or taking them to basketball or whatever. That's their behaviour. They're still leaning heavily on you because they know you'll step in and do it. Yeah.
So you could have a calendar somewhere where the kids can't see it, and every time they didn't pick them up or every time they forgot to or they bailed at the last minute, because we hear of these where they insist on 50-50, but then they just, I'm going away this weekend, you'll have to have them. And they just come up with all these excuses. So if you can mark all the times they've missed or dropped the ball, when you do it, if you get to court, you can say, look, it's not working. This isn't going to work.
I like a chronology. Everyone knows how much I love a good crunchy chronology. It's very fertile ground for a barrister for cross-examination. If you've got a chronology that has not only the date but the time that things occur, because sometimes it's a flurry of activity over an hour or so as someone drops the ball, insists someone else picks them up, all that sort of thing. You might get almost no notice of these changes. I've known of people who can't risk leaving their house or the area when the children are with the other person because they never know when they're going to get like 10 minutes warning that they have to go and do something with the kids.
So if you've got that in a chronology, that makes more sense than to say, oh, they bailed on Saturday, when they could say they bailed on Saturday and they texted me 10 minutes before and they dropped the kids at the front door, not even checking out. So all of that could be put in a chronology.
Yes. So you would put actually 4:30 message from that sort of thing. So so that, because judges more oriented, I dare say, to reading a chronology than a pictogram. When I did a teaching degree in the middle of my law degree, and I was trembling the first time I had to write something like in a shape on a file cover. That's the only cardboard I had, because we are so trained to be lineal. And it will be very helpful for you or your counsel, your barrister at cross-examination, but very helpful for the judge. And it's really, you could put each incident to them at a time.
So by having a chronology of all the times they fail, can that be proof if they still insist on 50-50 or more time that they're just not being genuine?
Yeah. Or that it's not in the best interests of the children.
Right.
You don't have to I don't think you should, in most cases, make the submission to the court that the person is just doing it to get more property. The court's going to be looking at the best interests of the children. So you would be making the submission that you're the one who's got the best interests of the children at heart. And like we said, child-focused.
So if someone gets a letter from the lawyer and they say, such and such is willing to offer you, 60-40 property split, as long as you agree to, something kids split. Is that allowed? Are you supposed to be doing that? Is that illegal or legal?
It's pretty awful, and it's a brave person that would put that in writing.
Right.
But we all know that's going on in some people's minds. Some people, if you're so worried sick about the children, speaking from personal experience, I said, yes, take it, as long as they stop the custody case.
And I think that's a lot of people who listen to this, I think. And we've spoken to a lot of people who just give in on property because they just want what's best for the kid. But is there other ways to deal with it other than just dropping the rope?
I think in mediation you can pretty well do it like. And sometimes the issue of property and then children, they come and go. Technically, of course, you really need to sort out the children's issues first if you're going to look at future contributions in terms of child raising and housing and so forth. But sometimes you can be more subtle than that in mediation. I think outside the door of the court, it's a very common conversation. My client says that they'll drop the 50-50 if you let them have this. Or my client says that if you don't, actually, this would be a terrible thing for anyone to take, a lawyer to take to the other person, but I've heard of it done. If you persist in seeking more than 50-50 with the child, I'm going to insist on taking this matter, the property matter, all the way to trial, or I'm going to tell them about this, or I'm going to raise this issue. So of course, there's a lot of blackmail going on in there, and the lawyers don't have to convey it. People know.
If anyone's listening today and they're like, I didn't realize there was a connection, are there any red flags that they should be looking out for to figure out if that is the reason? Because once you know the reason why your ex is negotiating what they're negotiating, it's a lot easier to mediate or negotiate with them because you know what the end goal is. And we talk about that in a couple of our mediation episodes. So go and listen to those. But what are kind of the red flags, Mum, that you see when people are trying to negotiate property and custody, where the red flags are showing you, okay, this person just wants more custody because they're worried they're going to lose property? What red flags do people need to look out for?
The red flags for me, one, the expression 50-50, because you don't hear people say, I'll go 60-40 with the kids, I'll go 70-30 with the kids, I'll go 50-50. You're not dividing up an apple at preschool. You know, you're not going halvesies.
Yeah.
So that tells me, and it was found to be the case, I think, by the Law Reform Commission, that a lot of people were seeking their full 50-50 of the children for financial reasons, either for property settlement or for child support, to lower their child support. And so another red flag for me is when people start talking about nights. How many nights am I going to have the child? Because that used to be how the Child Support Agency assessed the child support payable. One of the ways that people can keep contact with their kids in their busy lives is to go and have dinner with them, or a couple of times a week, pick them up from sport and really get involved. But sometimes those people insist on the overnight, and it might be for valid reasons, but really a lot of people, it's just to build up their number of nights that they can have with the child.
So if they start talking in child support terminology, that is a red flag.
It is a bit of a...
Is it a red flag if they want to do property first and children second? Or is it a red flag if they want to do property and children together?
It's hard. Most people do children first, right? And if they're going to manoeuvre with the children, they would want to get that done out of the way, children, so they can benefit in the property settlement, you know.
But I've heard of so many people where the ex won't negotiate children's at all until property is done because they know that the other person will get a bigger uptick because they're the primary carer, they'll have more time. If that's the red flag, the way they want to do property first.
It can be a real red flag. Do you know a big one though? If a person there's issues with one of the parents, and in the interim you propose supervised time for the safety of the child, right? And a lot of people where supervised time is offered actually refuse to go to see the child. And I think it's because A, they don't want to be told what to do if you've got one of those personality types. But secondly, going to see the child at a contact centre for 2 hours on a Saturday or Sunday or whatever it is not going to reduce your child support one jot, and it's not going to increase your property settlement at all. So I think that's a red flag for me, because if you truly loved your children, and if they were in the grip of someone who was maliciously accusing you of things, wouldn't you go? Wouldn't you go every minute you could possibly go?
Yeah.
So that's a big red flag for me as well.
Okay. Some people who are listening may be banging their head against a wall because they cannot figure out why their ex will not agree to property and children's matters, and they're going around in circles. Maybe this little hidden connection you might not have been aware of yet. If you haven't gone to see a lawyer, you may not know about these future needs and considerations for the children. And so it is really important that you learn about that and educate yourself on that, because we hear a lot of people getting tricked and swindled We did that episode on how to prove that you might be the primary carer and how to make sure you document that. But I'm just going to put it here just as well. The other red flag is if your ex has seen a lawyer, but you don't know, you haven't split up yet, but all of a sudden they're parent of the year and they're starting to take the kids to school when they've never done it in 7 to 8 years of their whole entire schooling career. They started making lunches and they're taking photos of it, putting it on Instagram, and they just come home early from work and take on some of the role. And some people might be going, thank goodness I don't have to do bath time tonight because my Neil ex is finally stepping up. But they might not realize that's a red flag because they've been told by their lawyer, if you are not the primary carer, you might not get a bigger share of the property, which makes me want to vomit in my mouth, to be fair.
Well, let's think of this though. There are also those people who suddenly get a wake-up call when their ex calls time on the marriage and think, oh my God, I thought I had all the time in the world and I want to spend more time with my kids and that may be something that's happening. But if you want to document that and preserve your role as a primary carer, we talked about how you can send an email to them or leave notes for them, but photograph them, saying how to do their lunches, where to drop off is, what time assembly is, and all of those things as you transfer some responsibility to the previously non-responsibility person.
So go and listen to an episode, please, please, please. Now, Mum, we've talked about the link and the horrible warnings that people need to look out for. Let's talk about some strategies people can take. And not everyone's going to be in court, right? Most of the people are going to be negotiating this themselves through lawyer letters or going to mediation.
Or parenting plans or something like that. Never see the light of court, and that's great.
So what is the safest way to negotiate with your ex if they are using these kind of tactics? How can you negotiate with them? Do you just go to court or can you try and be strategic?
I think mediation is still important in this role, and it may not benefit you sometimes to call them out on stuff because it just makes everyone at daggers drawn, you know. What you can do, though, is focus on what's been happening up till date and emphasise that so that the primary carer status quo thing is so set in stone, and this new flurry of activity is merely proving that this person is able to have the children a few nights in a fortnight. You know, there's a worrying thing. If you've got a lawyer who's been admitted for, say, 20 years, wouldn't you think that was a very experienced lawyer? They got in their degree or their admission as lawyers about a year before the law changed to 50-50. So really that's all they've ever known. And it's only the old boilers like me and the old school. We remember the 30-odd years before then where the best interests of the child was paramount. And so we know how to promote what happened in the past and to elevate that to an important status. So it may be some of our listeners will have to educate their lawyers a little bit and look at some of the older cases about how the court proves that. I'm worried about the number of people who have been, anecdotally, we've heard it, haven't we, Lloyd? They've been pressured by their lawyers into accepting 50-50 children. And in fact, when the court changed from 50-50 childcare to best interests of the children, the General put out a flyer, remember? And they said, we didn't mean that. We didn't mean that it was automatically 50-50, but it's just that the lawyers thought that and they started making consent orders to that effect. And if that's the case, the judges might have been championing to get a case in court so they could prove differently. I have to say my experience was not that was happening. I believe the bench was also fully on board with the 50-50 as well. So you've also got judges who, although they're being retrained, probably came up through the ranks while there was the best interest of the children wasn't a deal. It was the 50-50 arrangement, equal shared care.
Okay, let's go through what the child's best interests are. I've got Section 60cc from the Family Law Act from 1975 in front of me with the changes. But before we go through that, I just want to point out there's one thing we haven't thought about, and that is there will be people out there that do genuinely think it's for the best interest of the child that they live with them most of the time and see the other parent less of the time. But that other parent may say, you're only doing this because you want more money in the property settlement, which is the banner that's being flown by some of the men's rights groups. That's just greedy mothers wanting money for child support and for property settlement. And there will be people listening today who may very well be battling that worry that is that what I'm doing? Or is it because I care about the kids and I know that's the best interest of the children? What do you say to those people who are getting that thrown at?
I think in a lot of cases, the other person is projecting onto you, particularly if you have been the primary carer. I listen to what the opposition say, hi, men's rights groups, and I use it to calibrate responses and to try to negotiate with them. Sometimes, though, if you've got a really radical person on the other side who is completely wanting to obliterate the role you've previously played with the children, my advice might be to think about going to court earlier rather than giving them heaps and heaps of times to rewrite the narrative so that by the time they get to trial, they have been equal carer. Sometimes the family reports will pick it up. Do you know, anyone who's listening to this who already has sorted out their children's matters but may not have an outcome that they really wanted if they were pressured into it, the sad news is you're stuck with this.
If it's a final court.
A massive change, yeah.
If it's a parenting plan, different, but if it's a final court order, you are stuck with what you've got.
Pretty well. You've got to get over the rule in Rice and Aspland, which is now codified into the Family Law Act. So have a look at that if you're stuck and the orders are untenable. But I like to think mostly that orders start off, everyone's working to the letter, it's 4 o'clock at Macca's and it's 8 o'clock at school or whatever. And then after time, my idea is that becomes just a crinkly piece of paper in the back of someone's wallet and you guys are managing the children. Because even if it's not 7 nights or 5 nights and 2 nights and 5, even if it's not equal, you are still co-parenting, no matter how little time the other person has to spend with the children. And so I do hope for everyone that a new normal will arise because kids have a very short childhood that they remember. It's not far between 3-year-old when they're just starting to recall things and 13 when they're eye-rolling you and wanting to text their friends or be with their friends more than with you. So you've got 10 years and you don't want 3 years of that fighting over their future if you can possibly help it.
I know, but it's so unfair because it's usually just one person that's being the poop.
Yeah, being unreasonable and you're trying to keep kids safe, I get it. And that's probably better than letting them go into a situation that might not be safe for them. So more power to the people who are defending the kids and looking out for their best interests.
So let's have a look at what the court determines is in the best interest, according to the Section 60cc, the new one. So obviously right at the top, they mention if the child is Aboriginal or Torres Strait Islander. So that is obviously a consideration. And then general considerations, they are right at the top, 2A, if the child has been exposed to family violence, abuse, neglect or harm. So that's right up the top there. If they have, then they consider that a child.
Well, it's interesting that they put it at the top because they have distinctly said that those different issues, none of them are in any order of priority, right? It's just one of the factors. However, the court has a need. I think you'll see the objects of the Act are to protect the children from emotional, psychological and physical harm. And if there's been family violence or the observation of family violence, and it's defined in the Family Law Act. So if they've been exposed to it, if they've seen the police come, if they've had to clean up after an incident, if they've had to comfort a parent while they're upset after a row, all of that is being exposed to family violence. So if you're wanting to show what is in the best interest of the children, that Section 60cc and each of those headings that apply, you really can't do better than that, I don't think. You just give your
information. Put the heading and information.
I always thought it looks very pedestrian. It looks there's nothing flowery about it. Oh, Your Honour, this. It's like Section 60cc says this, and then you do the heading and then you put the fact.
And you said that's what the judge does anyway. Isn't that what the judge has to do?
Yeah, I remember one case I'm very proud of when I was at the bar. He practically cut and pasted my submissions. They were so basic, like times tables, but I had columns. But actually, it meant I didn't miss anything, and it meant the judge was able to say, well, I won't get appealed if I follow that.
Okay, so let's go through it. So we've discussed, obviously, if the child is Aboriginal or Torres Strait Islander, there needs to be other considerations. But the general considerations, if the child's been exposed to family violence, any views expressed by the child is the next one. Developmental, psychological, and emotional and cultural needs of the child is the next one. The capacity for each person who is going to have parental responsibility or care for the child to provide for the child's developmental, psychological, emotional, and cultural needs. Then there's the benefit of the child being able to have a relationship with the child's parents and other people who are significant to the child where it is safe to do so. So that's like grandparents, etc.
Yep, if it's safe. Yep.
And anything else that is relevant to the particular circumstances of the child. But the court must include a consideration of any history of family violence, abuse, or neglect involving the child or a person caring for the child, whether that or not the person has had parental responsibility for the child, and any other family violence order that applies or has applied to the child or a member or the child's family. And there are a couple more considerations for the Indigenous ones that include the child's right to enjoy their culture, having contact and connections with them, their wider members of the family, and be able to explore their cultural views and develop that's consistent with their culture. So there are those things, but realistically, it's basically pretty straightforward. It's saying, if there's family violence, we're going to look at it. And then it talks about basically what's going to affect the child's psychological, emotional, and cultural need. But then also, does that other parent have the capacity to provide psychologically and emotionally and culturally for that child? And I think that capacity to provide for the child emotionally is a big one that I don't know if many people realize that's there.
Well, they may not, because it wasn't really there in the older legislation, right? It wasn't a big feature. And I did, years and years ago, I acted for someone, and her psychiatrist wrote a report that actually diagnosed this lady as a narcissist. But what they said in the report was that narcissists are unable to love anyone else. And that was just a by the by from the psychiatrist. But I'd be interested to see what studies there are. But most people don't get that diagnosis. Like we call it manipulative and controlling behaviours, and that might be all it is. Some of these people are lovely to everyone else outside the family, just horrible to you, you know.
So when it comes to deciding on the needs of the best interests of the children, it's all laid out there. I'll put it in the show notes for anyone. But really, it is a psychological battle, I think, this hidden connection for people between people who are doing the right thing, like amicable. They're not going to be manipulating this in any way. They're going to be wanting to do what's right, making sure the children are provided for, making sure the children are in the places they want to be in, and making sure the property settlement is fair. That's amicable. And if that's you guys, that's fantastic. But if you're in high conflict, that may become an issue when you're fighting over who the primary carer was. But like we always say, Mum, with high conflict, the best way to deal with them is facts. Document.
Evidence.
So the sooner you can start documenting what you're doing with the kids, because that is going to stop any fights with those people. But if you've got manipulative and controlling, I think that's where a lot of people are getting stuck, because if you've been in a coercive, controlling relationship, that you probably already think you're a bad person, or you've been told so much that you're a bad parent, a bad person. And then if they say anything, even after you've left, you may still feel what they say is true because you're still self-doubting yourself. And I do worry that there's a lot of people out there who are worried about what others will think of them or what their ex is thinking of them, and they just want to do the right thing. But you've got to think about your kids. And whilst there are TikTok videos of other women yelling at women for getting child support and calling them lazy and how dare you, I don't need child support, I've always looked after my kids, I don't need anybody else's money. All that crap that goes out there that tries to shame you into not doing what's best for your kid and quieting you and shutting you up. I think ignore that stuff, block, delete, and ignore, because your kids' future will be better if they are doing what's best for them, the best interest of them. And if it's spending more time with you, then you've got to fight for it. And if that means property settlement, you get more. It's not you that's going to get it. We all know where money goes. If you've got kids, it goes to doctors, it goes to school shoes, it goes to schools, it goes to all the little things you've got.
Dentists, camps.
I have never yet
lessons.
seen a woman walking around with shoeless, sad, teethless children while she's got her nails and hair done in high heels and a Gucci dress. It's just not reality. They want you to think that's who you are, but it's not who you are. So I really want to reach out into the microphone to those people who have been attacked by that kind of rhetoric and tell you you're doing what's best for your kids, and you remind yourself that every day. And Mum, the avoidant type, when it comes to this battle and hidden connection between property and kids, do they deal with it?
The other person.
Do they need it? Is it an issue, or is it just manipulative?
Yes, I don't see the avoidant people raising it very often.
Yeah.
Like, they may have reasons why they're not very outgoing, and they probably don't want to be involved in arguing badly about the kids.
If you are avoidant, though, your personal self-avoidant, and you are having a property settlement, and you know that you should get a larger uptick because you've got the kids more, please try to get someone to help you. Don't just leave it, because you may kick yourself in the future when you've got to pay some big bill. Oh, I really wish I'd got a bit bigger property settlement.
Kids aside, even without the kids, if you've got someone who's manipulative and controlling or very high conflict, who's constantly shouted you down through the relationship, that's how you end up with less property than you're entitled to. And they get more because they just keep doing it. But the consequences can be devastating. But my thoughts are that when it comes to kids, the consequences are devastating for the kids.
Yeah. And at the end of the day, like you said, Mum, they're only kids for a little while. You've got to do what's best for them. And I know that the people listening to this podcast, obviously, if they're listening to a kids one, they're trying to do what's best for the kids. And I know people will point at you, go, oh, only the bad people end up going to court. What's wrong with you? I had an amicable divorce. We went and saw the same lawyer together. What you need to be saying to them, like, good for you, but I've got to do what's best for my kids. And that's what you've got to say and remind yourself constantly. And I think if anyone's in this stupid hidden battle that goes unspoken, which annoys me, Mum, have you ever seen it pointed out by a judge or a court where they've seen it and seen that they've used ever?
Not since 2006.
Okay.
But I did see it in the earlier stages where, especially in interim hearings, the court had a case of cowling and cowling, which is now back in favour, by the way, C-O-W-L-I-N-G, where the cowling and cowling's case was, if a status quo has been established, whatever was happening with the kids before you've come to court, we will put that back in place most times. And that can stay like that till your final trial. And so you would see people trying to rewrite history frantically there. But because it was on an interim basis, because it was pretty quickly after separation, they didn't have enough time to establish a false narrative. But it's been around. It's been around for ages. I think the best interests of the children, it's very hard for a judge to discern. They can only work on what maybe the social worker or family report writer said, child impact study, family consultant, the independent children's lawyer, what each of you says. What we really needed was to envisage someone who was there the whole marriage, looking down, and who would say at the end, you know what, I know these guys, I know these kids, and they definitely should be with this parent. But in the absence of that, we are all looking back through sort of murky looking glasses. And it is the one time where retrospective looking back is important. I often tell my clients not to dwell on the past, but you probably weren't writing things down. It's probably been insidious. But the minute it twigs with you, try and recollect some things that have gone on in the past and keep track.
And I think if this is the first time you've heard of this hidden connection, it may help the behaviours of your ex make more sense. It may bring to your forefront of your mind during mediation if things aren't going particularly well. And you may have to weigh up, and that go see a lawyer. We're not telling you what to do, but what's more important for you? Is it the children or the property? How long do you think your ex is going to drag this out? be aware of their intentions and their hidden reasons. And those red flags can give you a bit of a clue. But I think once you understand what they're actually thinking and why they're doing what they're doing, it can be easier to negotiate because you understand the levers that you can pull.
Absolutely.
Mum, is there anything you want to embroider on a cushion?
No, I don't want to think about this at all.
Well,
but if you were going to, you'd do it in gold and say the best interests of the children.
Yeah. And I just want to put a little shout out to one of our lovely members and listeners who made this for us. It says Angels.
Oh.
And she sent it to us. It's a beautiful version. She made it herself. I'm super loving it. And Mum and I are going to take turns having it in our rooms. But thank you for sending that to us. We absolutely love. Mum and I cried. We cried because she's obviously through the end of it. She's gotten all the way through. She's happy. And so we really appreciate that. Cried. So thank you, Mum, for everything that you do for us.
Darling.
And if you are listening to this and you're going through this, biggest hugs. It doesn't go forever. You can get through it. So thank you, Mum. And please go listen to that other episode if you haven't about protecting your primary carer role. And we'll see you guys next week. Thanks.
Proud of you, darling. Bye, everyone.
If you found this podcast helpful, we'd love it if you could rate, review and subscribe. By doing so, you are spreading the word to help someone else just like you. Lynn would like to remind you that this podcast is general advice only and you should always get legal advice in relation to your particular situation. And remember that the Australian laws may have changed since recording.